Okay, so if you're watching this video, you've probably been informed that we've set mediation in your case. I wanted to give you some specific instructions about that so that you're prepared and you feel comfortable going into that mediation. So first of all, why do we have to go to mediation? So another step, it's going to cost you some money. So I want you to know why we're having to do this. And the first thing is that our judges absolutely require it. So that's why we're going. We're going because we have to. Now, the other reason we're going is that this can be a very effective way to get your case resolved right there at mediation and be done. And so that is my goal for you, that we're able to get that case resolved for you at mediation. And because of that, I want to make sure you and I are best prepared so that we can be in the best shot of getting it done and getting it finalized at mediation. So that's the purpose of this video, but that's why we're going. I want to talk about the idea. The idea behind mediation is that we get the case resolved. So we reach a full and complete agreement there at mediation. We'll sign. If we do reach agreement, we're going to sign it, and it's going to be a done deal. And we can't back out of that agreement later. But the whole goal there is to get that agreement. And so we're actually mediating we're mediating all these cases, but we're reaching agreement on a lot of these cases at mediation. So that's my goal for us, that we're going to make that happen. So what do we need to do to prepare to make that happen? Okay, first thing I want you to know is you do have to pay for the mediation on the day of the mediation. So I want you to have at least $250 available to you to pay the mediator. We pay half of the total bill. Most of our mediators charge between $150 and $200. We have a 2-hour minimum, so it'll be at least the $150, $200. But if we go long, because we're making progress, then we can. Then it might be a little bit more than that. So be ready for that. Most of our mediators take cards, so credit cards or debit cards. They'll certainly take a check or take cash if you want to do that. Where to meet for mediation. So the email that you received about this, that linked to this video, probably tells you where that mediation is going to be, who the mediator is, and where the mediation is going to be. If you have a Murray County case and you're told to meet at the Whitfield County Courthouse, that is entirely correct, okay? We're in the same circuit, and any Murray County cases that are mediated are generally mediated at the Whitfield County Courthouse. We have a few mediators that mediate at their offices. So Rob Cowan, Jeff Dean, Randy Bates, they mediate at their offices. So there's an address there in that email that'll tell you where that is. And I like to meet you at least 15 minutes beforehand. If you're told to go to the Whitfield County Courthouse, into the court administrator's office, you want to go to the Whitfield County Courthouse, take the elevator up one flight, and immediately in front of you will be a set of double doors. It says Superior Court Offices. That's where we'll meet for that mediation. And like I said, meet me about 15 minutes beforehand. So some of the rules of mediation, we go over what this looks like. Basically, you and I will be in a room. The other mediator, or the other side and their attorney, will be in another room, and the mediator will go back and forth. So we won't be put in the same room. I might meet with the other attorney and the mediator, but you won't be in the position where you'll be in the same room with the other side, number one. I want you to know that the information that we share with the mediator is going to feel free to share with the other side. So we want to be careful about that, make sure there's not something that we don't want the other side to know. If there is something we want the mediator to know, but not the other side, we can tell the mediator that, hey, don't share this information in the other room. That's fine. The other thing I want you to know about mediation is the proposals that we make. Let's say we make a proposal that the other side can have something if we can get something else, and then we don't get the case resolved. They cannot use that proposal that we made at mediation against us in court. Well, didn't you offer me to have this if you did this? When he goes to court, or he or she, you can't say that in court. The type of proposals back and forth are not admissible. So the judge is never going to hear that. So that's good. That makes us feel comfortable to make proposals. Okay, so that's important to know. The other thing important to know is I'm going to be there with you during this mediation. We're going to talk about it. It's going to be tough. Okay, you might have to make a tough decision. I'm going to be there to give you my best advice about how I think the case is going, about where you are, where the other side is, about what our judge might think about this kind of stuff. The mediator will give his best thoughts on that. But ultimately, this is a decision for you. It's going to be your decision to make. But it can be stressful because it can be tough to make these decisions. But I'm going to be there. I'm going to give you my best advice and suggestions on it. The last thing, I do want you to reach out to me and schedule a time for you and I to get together roughly a week or two before the mediation so that you and I are on the same page, so that I can answer your other questions, things like that. So feel free to reach out to me. There's a link in your in that email where you can schedule a 1-hour consultation with me or a 1-hour meeting with me. And like I said, I like to do that at least a week or so before the mediation so that you and I are on the same page. Great. Let me know if you have any questions about that, and we'll go from there. But I look forward to hopefully getting the case resolved for you at mediation. Thanks.